And we are live. And good evening. My name is Heidi Oropesa with Florida U Judge. And today I have two great guests, attorneys for with the ACLU, Jacqueline Aziz and Benjamin Stevenson. And we have an incredibly good topic to discuss this evening in regards to bail reform. The reason that I wanted to coordinate this discussion was in earlier this month, we learned through a article, a story published by the Tampa Bay Times that a Pinellas inmate who was being held on petty theft and trespassing in Walmart. And good evening, Getulio Gonzalez Mulitieri. He is a community activist. Welcome. He's, I'm sure, very excited about this topic. But yeah, we learned in the news in February that this gentleman, Alfred Woodard, he was arrested as a result of being suspected of petty theft trespassing at a Walmart here in Pinellas County. The total amount of the petty theft was around $32. Okay, I went and I saw the affidavit, the probable cause affidavit, and so the bond amount was $1,150. I know that as soon as that article came out, some of the attorneys in the legal community, particularly some that I had read some of the commentary on social media, Pactel, you're familiar, I'm sure both of you, with Pactel, Pinellas Association of Criminal Defense Lawyers. I know you are, Jackie, because in fact, Catherine Henry, who works at the Public Defender's Office, we had already spoken during the pandemic. You reached out, had an opportunity, but then once again, she connected us because said that you and your colleague were the gurus on bail reform. So very upsetting. A lot of attorneys expressed dismay and even anger at the fact that an individual that appeared to be a poor man was arrested for shoplifting, $32. And then there has a bond of $1,150 and is unable, presumably, why? Because he was in jail for 2 months and then ultimately he was found unresponsive and later died at a local hospital. So presumably he was unable to bond out because he was poor. So let's start off this discussion. And for those of you who have tuned in and who will be tuning in, you can either put in your comments for these two attorneys, Jackie and Benjamin, and or call. You can call the 813-221-9700. That is the call-in number for you to provide commentary or weigh in. You can call 813-221-9700. And so let's start the discussion with Jackie. I want to first ask you to educate the public about how does bail get determined. So that's the first stage, right? Somebody gets arrested, they're brought before a judge. Tell us a little bit about that and educate us.
Sure. So the way it works in Florida is first, when a person is arrested, they're brought into custody at the local county jail. And at the jail, the person is given a bail amount. And normally this initial bail amount is based on what's called a bail schedule or a uniform bond schedule. And for anyone who is unaware of what a bail schedule is, most, if not all, courts in Florida have a list of charges and then a corresponding bail amount for each of those charges. And so when an officer brings someone into the county jail, they will give them a bail amount based on this bail schedule. For instance, in Pinellas County, which is the St. Petersburg and Clearwater area in Florida, the bond schedule actually has a range. So for instance, someone who is arrested for most first-degree misdemeanors has a recommended bond range or bail range of $150 to $500. But a release on their own recognizance is also allowed under the bail schedule recommendation in Pinellas County. And then that, and what that means is a release on their own recognizance is they can be released without having to pay a bail amount. And so the person who's booked into jail, let's say for that misdemeanor, they're given a $500 bond. If they can bail out on that, they do. But if they can't, they go to what's called first appearances or advisories. And first appearances is something within Florida. You are required within 24 hours of your arrest to go in front of a judge. First appearances has three purposes. The first one is to determine whether there was probable cause to begin with for the person's arrest. The second is to determine if the person qualifies for the assistance of a public defender. And finally, the third reason for first appearances or advisories is to determine what the conditions of release will be, or the bail conditions that will be imposed. So there are many possibilities that a court can implement, like stay away orders if there was a victim involved, or if someone stole from a store, forbidding alcohol or drug use potentially, maybe GPS monitoring, pretrial services if the jurisdiction has pretrial services, and so on. And of course, the court can also require monetary bail. But what's important to know about Florida bail is that the law in Florida actually requires a presumption in favor of release of non-monetary conditions unless the person is charged with a dangerous crime. But that's not happening in Florida. And, in Florida, we have very broad sunshine laws. Essentially, anyone can go in court and observe this or watch it online or look up the records later of what happens at first appearances. And anyone can see who watches first appearances or advisories that the presumption of non-monetary conditions is really not happening in Florida. It's more of the exception than the rule, unfortunately. And if you also watch, you'll notice judges really only spend a few seconds deciding what someone's bail amount is, oftentimes not even considering that the law requires a presumption of release on non-monetary conditions, unless that person is charged with a dangerous offense. So rather, monetary bail in Florida has become the norm, not the exception. And non-monetary conditions have become the exception and not the presumption, which is in direct contradiction to what the law requires. So that's kind of the summary of how someone gets bail. If at first appearances, they don't like their bail, they can speak with their attorney and do what's called a motion to modify bail. Those don't happen all the time. It also takes time for the attorney to meet with their client, determine they want to do that, and get the hearing set. So it is quite a process for people who can't bail out initially.
I had to unmute myself. I apologize. Okay, so Benjamin, I want to ask you, you wrote an incredible article, and I would invite those who are viewing and who will view to read this article. It's amazing. I want you to now, if you could get into the law in Florida and address, since Jackie touched upon the presumption in favor of non-monetary, you addressed in your article, you referred to a Florida procedural rule, which the courts have to go through in making a determination to maybe not make it a monetary bond unless, and if they do, there has to be less restrictive conditions, other than putting something, imposing a bail that they cannot afford. Did I understand that correctly in your article?
Yeah, I think you largely got it right. Haiti, thanks for having us on.
For sure. Yes.
Fantastic. I think it might make sense to maybe just even take a step further back, and think about what is going on when we are having a bail decision, when the judge is trying to wrestle with, and frankly, the community is trying to wrestle with, weighing two important issues. On the one hand, you have personal freedom, personal liberty. And on the other hand, you have an interest that we all share in people being brought to justice, whatever that definition of justice may be. That may differ, but I think people do want justice. People do want people to be accountable. And if there is some concern that some people don't show up to trial, I think that concern is well overblown. I think the vast majority of the people who do not appear for a criminal proceeding, it's not because they're on the lam, that they've somehow fled to another country or Mexico. It's because they didn't have, they couldn't get off work. They didn't have good transportation. They had childcare concerns. They got sick. They were in the hospital. These are the reasons people miss court. And so, unfortunately, there's a lot of conflating this concern of, oh, well, we need to make sure that they're going to come to justice.
Benjamin, I don't want to interrupt you. I want you to continue on, but let's
Yeah.
take this case as an example, right? I'm presuming this, and sometimes maybe judges presume this. This gentleman may be homeless, right? And how
Right.
do we get this person to court? I don't see how a monetary condition is going to make that happen, but is that the thinking? Like that's
No, I
going
mean-
to procure their presence at court? All
Yeah,
right.
that is, yes, that is, if you were going to ask someone honestly, why are they imposing a monetary bail? I think the idea is to provide an incentive for people to show up to court. Of course, in how bail works today with the prevalence of a commercial bail system in which you don't pay, let's say $1,000 bond or $1,000 monetary amount bail. You don't pay $1,000 cash. It's rare. You can, but it's rare, and it becomes exceedingly rare when the number is not simply 1,000, but it's 10,000 or 100,000. People are not ponying up briefcases full of cash without any suspicion about where the cash came from to secure their release. What they're doing is they're going to a bail bondsman. Now, what they're doing there is purchasing a financial product. It's very similar to a mortgage. It's very similar to a same-day, payday loan. It is leveraging the rich over a poor person on the promise on the actual, not promise, but the actual payment of 10% of the face amount. So if you had a $1,500, I think Mr. Woodard had a $1,500 bond. Is that right?
It was $1,150.
Okay, so he would have had to put up $105 to secure that, to buy that bond. He puts up the 105. He never gets the 105 back.
Right.
If you put up the 1,050 and he shows up, he's going to, got a good chance of getting that money back. There is a weird part about Florida law about taking court costs out of
Right.
unforfeited bonds. But largely speaking, that's the concept. We're going to incentivize the person not to not flee, to stand trial, to face their peers on the idea that we'll give them the money back.
If he doesn't want to show up, if he doesn't want to show up, what does he care about losing that?
Well, I think that's exactly it. The premium is paid, and you're never getting it back. Where's the incentive? All of a sudden becomes very strange, right? Where is the incentive there? And so I think there is some question there. Of course, there's bail industries that are, they make a lot of money off of this.
Right.
Yeah. So yeah, I think that is generally how it works. I think there's probably two more just kind of foundational ideas that I think make sense to get out first. And the first is what I hear from some critics, some opposition. They say, listen, we just arrested someone for committing a crime. Why are we going to let them back out on the street? Now, to be fair, it has a certain amount of logic, right? Better or worse, the conviction rates are fairly high. So if you are arrested for a crime, you're most likely going to be convicted or plead to a crime. Whether you get jail time or prison is another question, but the conviction rates are fairly high. And on a serious crime, the chances are high, that, or at least decent, that you're going to be looking at some prison time. And so the logic is, well, maybe all we're doing is trading time in jail before trial for time after. If we release them now, they're going to end up serving 5 years. Let's pretend that the guy will serve 5 years. He's going to serve 5 years either after trial or before, or a combination of the two. What's the harm? And I think that points to, in my mind, a foundational issue or foundational concept of our country, and it's the presumption of innocence. Anytime somebody says, what's the harm? Why does it matter? He's obviously guilty. He obviously needs to be here because of what he's accused of. What is it? What are we hearing? What's being said? What we're hearing and what's being said is we know he's guilty. But that is not how our adversarial system works. That's not how the criminal justice system works. It is not, we don't know something until it's determined. And I know that sounds strange. You know, I think
right. That's the truth. That's it.
But I mean, it also speaks very highly of our society, that even when we know someone's guilty, we still have a trial because that's who we are. It speaks to who we are. And I think when you're not recognizing the presumption of innocence, when you're unconcerned about pretrial detention because it's an offset from post-conviction detention, you're missing that element.
And also, listen, they're being punished. That's punishment. When you serve 2 months in jail and you can't afford to bond out, that's tantamount to what could later be a time served. You've already been punished.
Right. Yeah. There's a lot of truth to that. Certainly.
Can you go into the excessive bail versus the unaffordability of bail arguments?
Yeah, no, and I think the critical question that, listen, for decades, everyone, the watch sign and the question for everybody is excessive bail. Is the bail excessive? Excessive, in parroting what I was talking about before, excessive is a measurement of two ideas. On the one hand, what is the monetary bail? And on the other hand, what's the state interest? What's necessary to make sure that they come back to trial? And when it's greater than necessary, it's excessive. That's what that is. But the reality is, excessive or not, the critical question for most people is not whether it's excessive or not. I'll give you an example. If you have a person with a very wealthy person and the bail's $100,000, and it's excessive. It should only be $10,000. But what's the difference? The wealthy person is only being deprived of the benefit of their money of $90,000 for a period of time. That's the difference. And so it really is not that. That's not the critical question for most people, because that's I would say a nominal issue. What the important question is, can I get out of jail? Will I be released? That is the difference. That is what affordable means. Has the court set a condition of pretrial release which will actually facilitate pretrial release instead of ensure detention? And so it's not really the question of excessive. It's a question of, is it affordable?
Right. Why do you think, Jackie, that the court system during first appearance, like you referenced, they don't do a more thorough determination and just like kind of just go through it real quick, like, you know, and not really make a thorough determination based on, like with this gentleman? How did this happen to this gentleman? Huh?
Well, I'd be totally guessing because I do think it depends.
Of course.
Yeah, jurisdiction to jurisdiction and judge to judge. Generalizing, to answer your question, I do think it's just the way it's always been done, right? Courts look at a bail schedule, they decide, okay, well, we decided this is an appropriate amount for this charge. If there's a problem, someone will file a motion to modify bail, I think, is, if this becomes an issue, the assigned judge will hear about it in a motion to modify bail. And also at first appearances and advisories, there are, depending on the county you're in, a lot of individuals there. First appearances and advisories can take hours and hours. And so judges probably just honestly don't have a lot of time to spend on each individual. But I think, you know what, that's what the Constitution requires, is an individual, and that's what our law requires, is an individualized determination. And if that means taking an extra minute or two on each individual, I hope judges will do that. And I think courts should do that.
Jackie, now that you're on that address, I mean, I'm sure most in the public, the community will understand what kind of hardship effects does it have on somebody to not be able to afford to get out of jail, and to stay there. What effects does someone in that situation suffer?
And I just want to preface this with, I was an assistant public defender for 3 years before I worked for the ACLU of Florida. And so I saw this firsthand in my client's experience. You know, people can lose everything if they're sitting in custody pretrial. And these aren't, I'm not talking about individuals sitting pretrial for a day or two, although a day or two can be devastating for people. But individuals sitting pretrial a week, 2 weeks or longer, and in Florida, often it's months before they get to trial or accept a plea agreement, they can lose everything. Once they lose their jobs, they lose their homes, they lose their personal belongings, they lose their relationships and their connections with people, and sometimes parental rights. I mean, and I think importantly, especially when I was a defense attorney, people who had a defense they want to present, if they had evidence, if they had witnesses, they were really hampered by and limited by what they could do. If they're in custody, they're not out there able to collect their witnesses. They're not able to collect their evidence. You know, they are having to tell their defense attorney, you know, you got to speak to this person. You have to go here. You have to get this. And they're not able to even assist in their own defense in many ways if they're stuck in custody.
Right. And sometimes evidence, it's like time is of the essence, right? To gather
Absolutely.
it, to get it.
Absolutely. And I think both, everyone else had something they wanted to chime in. I saw the mute buttons change, so I'll let them jump in.
Okay, so I'll let Tulio, do you have any contribution to what we're discussing? I'm sure you do.
Yeah, Jackie pretty much touched on a lot of what I wanted to say, especially the parental rights portion. But as far as all this goes, yeah, cash bail needs to end. I believe it was Governor of Illinois. They just today he signed a bill to end cash bail out there. It's a problem because from my perspective anyway, and the people that I work with and I grew up with, let's say somebody's accused of committing a crime, right? More often than not, the system that unfortunately is impartial, is biased. They look at people with a certain skin tone or a certain ethnicity as something like, oh, you know, the assumption is that they're guilty, or the presumption is that they're guilty. Unfortunately, you know, innocent until proven guilty, but that's just not the way it works. We're all human, we're all flawed, right? But the problem is this individual, it gets told, listen, whether you committed this crime or not, you should take this plea deal because it's going to be a lot easier than, and if you can't afford the bail, you're going to take the plea deal. And somebody ends up serving time for a crime that they didn't do. This happens every day. I'm sure everybody on this call knows this. And yeah, like, I have to speak on it because if I'm going to Tallahassee and talking about how HB1 and SB 484 is unconstitutional, cash bail, if I'm not mistaken, goes against the Equal Protection Clause of the 14th Amendment. So yeah, that's pretty much where I'm coming from it with all this.
Thank you for bringing up the fact that Illinois, there's just a change. And Jackie, can you elaborate, your Benjamin, on that? That's part of bail reform. That's huge. Touch upon that and just bail reform in general.
I'll just mention Illinois really quick is, as far as I know, has become the first state to abolish cash bail. Now, New Jersey and DC have nearly eliminated cash bail, but not completely, to the point that Illinois just did. And I hope and anticipate other states will follow in Illinois' footsteps, or at least maybe what New Jersey and DC has done. And I do want to think of, or mention one other thing I thought of, that, you know, when people are sitting in custody on an unaffordable bail, they often want to give up, importantly, a lot of arguments they have. For instance, if I had a strong motion to suppress or a motion to dismiss that I wanted to present to the court on behalf of my client, oftentimes my client would rather take a credit time served offer, as it's called, than wait the extra week until the hearing can be heard. And that was so common. I'd filed motions to dismiss, I'd filed motions to suppress, but then the state would offer a credit time served offer and the client could get out right away. And the client would say, forget it, I'd rather plea, and, lose that opportunity to essentially have the case dismissed.
And then they have a record that can impact them.
Absolutely.
And then, God forbid, if they come back into the system, that very charge that they shouldn't have pled to is then shown to the judge as part of their record in making a determination for pre-trial release conditions. Benjamin, would you like to go over a little bit? And again, if you like to call, for those of you who are viewing, the number is 813-221-9700. If you'd like to call and ask Jackie or Benjamin any question or make a comment, weigh in. The 4 less restrictive conditions that you talk about in the article under
Right.
the rule.
So the reality is unaffordable bail is simply one of numerous things that the court could impose that are equally illusionary, meaning they cannot be satisfied. If the court said, I'll release you if you time travel, or if you pay the national debt, or if you grow a third eye, all of this would be obvious to everybody. But it's kind of like a quick dance. Oh no, we're not actually imposing pretrial detention. What we're doing is simply imposing bail, and whoops, it turns out that you can't afford it. There's more at stake here. When you impose an unaffordable bail, you're imposing a condition that cannot be satisfied. The result will be pretrial detention. Now, the due process clause, people have heard this, the government shall not deprive a person of life, liberty, or property without due process. And it turns out what due process is a very flexible concept. If not much is at stake, you don't get much. If a lot is at stake, you get a lot more. And the question then is, well, what's at stake and what should the process be? You think about when we, at the culmination of a criminal prosecution is a criminal trial, where we provide a significant amount of due process. We give people lawyers. We allow them to cross-examine people. They can call their own witnesses. They can be heard. They're heard by a jury of their peers, because there is a phenomenal amount at stake. And alluding back to what Jackie was saying, at first appearance throughout the state, many of these decisions are made within a half a minute to upwards of 3 minutes. And this is a decision that will affect a person, not only about a plea, but even if they decide not to plea, they could be looking at 5, 6, 7, 8, 10 months of pretrial detention. I was talking to a gentleman today. He's been there for 2 years of pretrial detention. That could have been decided in fewer than 30 seconds.
Especially now with COVID.
Right, exactly. I mean, this is a wild concept. And so the question is when liberty, not simply money, but when liberty's at stake, it turns out, rightly so, and if people thought about it, it makes sense, that more due process is due. If you're going to take someone's liberty away, time and time again, throughout the case law of the U.S. Supreme Court, throughout the Florida statutes, in various other scenarios, if you want to take away liberty, you have to do 2 things. The first thing you have to do is say that nothing else would work. The second is you have to show that some clarity or some certainty in that conclusion. So it's not that you, generally speaking, that means that you have to prove by clear and convincing evidence or more that there are no other alternatives. And with respect to a monetary bail, it's that nothing less and nothing else than this monetary bail that has been shown to be unaffordable will suffice. This is the only way we can achieve our goal of bringing this person to justice, assuring that they come to trial.
That right there, I want the listeners, viewers to really listen to this. If you have a loved one, someone you know is in jail and they can't afford to get out, then there are less restrictive conditions that in our Florida procedural rule, a court has to consider rather than opting to, well, if they can't afford it, they can't afford it. Too bad. No. And, you know, Jackie, we were talking about why don't we see this more at first appearance? And you alluded to, well, maybe the volume and maybe because later on we're accustomed to defense attorneys then later on asking for or filing a motion to modify it or to address bail again. Sometimes that could take a week, right? What can happen in that period of time? They can lose their job. A lot of things can happen in that time, right? So this is something I think I haven't seen. I've been practicing now over 20 years, and that's not the routine. What we're discussing here is not something that regularly happens at first appearance. It's kind of just, you know, next. And Ben and Jackie, where do you guys see this going? The Illinois just eliminated cash bail. I'm sure the bond industries, they're going to take a hit in that state. Not happy about that, but where do you guys see this going? Do you think this is going to generally be the whole country that's going to follow suit? Yes, no?
Certainly hopeful.
Yep.
Yeah. I mean, I think what we need to do is have an understanding of who we are, both from a perspective of liberty and the presumption of innocence, and where we want to be. And are we getting to where we are? Are we getting to the destination that we want to arrive at by simply, making sure large corporations, these sureties companies, are making phenomenal amount of money at the cost of county jail facilities, but more importantly, at the cost of people's relationships, their housing, their families. I don't know if that's who we want to be. I certainly don't want to be that.
We have a comment. Star Lynette Briggins, who's a local attorney, an activist. This has been such a wonderful discussion. Thank you, Haiti, Jackie, Benjamin, and Getulio for taking the time to educate the public. Jackie, ACLU, bail reform. What's ACLU doing?
Well, we have actually prioritized bail reform as one of our major issues in the criminal justice reform campaign that we have going on. We are working with defense attorneys across the state to help them challenge their clients' unaffordable bail. So we'd love to hear from anyone who's listening or interested, who want to pursue some options on how to challenge someone's unaffordable bail. We'd love to hear from them. And I can give out my email address, and we'd love to hear from them.
I'll go ahead and I'll put that in the, if you don't mind, I will share that with the public so that they can email you. Is that okay?
Of course, yeah. It's on ACLU website, so it's not hard to find too. So,
okay, great.
No
so problem. I'm just going to go ahead and put that in the comments section. And so thank you so much for joining me this evening. It was really a great discussion. And Getulio, same as you, thank you for co-piloting with me, co-hosting. Always a pleasure to have you on. And with that, thanks for those of you who have been watching, listening. Please share. This is very important, helpful information. Haiti Oropesa with Florida U Judge, with my co-host Getulio Gonzalez Moliteri, and thank you so much again, Jackie Aziz and Benjamin Stevenson, for joining me this evening. Everyone
Thanks.
have a great evening.
Thank you. You as well.
Thanks for having me, Haiti.